All right, kids. Let's get her started, shall we? Oh my, oh my, oh my. Ladies and gentlemen, welcome to the Weekend Court Review. I am your lone wolf, Usul. I am here to present to you a cavalcade of interesting cases. We're going to start off with Judge Boyd this morning. She had a real high-profile case this last week with a wannabe rapper who going to be spending the rest of his life in jail, but we're not going to be seeing that. We're going to be seeing some other stuff that happened in our courtroom the same day that guy sent away for life. And then after that, we're going with Judge Ricke to check in on a case that we have followed a little bit with a young lady who pled guilty to kidnapping. Then we're jumping over to Judge Simpson for some landlord-tenant stuff that we followed. And ladies and gentlemen, all of that starts right now.
All right, Mr. Mamori,
Yes, Your Honor.
are you all ready to proceed?
Yes, Your Honor.
Okay.
Just want to let you know, he will plead true, but with an explanation. That's.
All right, we're back on the record in 2022 CR 5993 and 2018 CR 5502 State versus Jalen Collins. And State, I believe you were reading the violations in cause number 2018 CR 5502. If you could read the violation, please.
In Bear County, Texas, the defendant Jalen Michael Collins did then and there failed to attend and provide verification of sober support / Alcoholics Anonymous / Narcotics Anonymous meetings for the month of January 2025 as directed in violation of condition number 18.
How do you plead to that? True or not true?
True. State waives the remaining violation allegation
No objection.
and shall I
Just one
proceed?
second. Did you understand by pleading true to violation of condition number 18? Just one second. All right, let's go off the record. Was he previously revoked? Because I show that he's on deferred.
My understanding, they were both adjudicated, Judge.
All right. All right, thank you. Now I see,
Judge Angelini adjudicated him from deferred on both cases.
all right, and did he make his underlying 8 years in each case? Oh, yes, he did. All right, we're back on the record. So did you understand by pleading true to violation of condition number 18, the court could find it true, grant the motion, sentence you to 8 years in the prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 18?
Yes, ma'am.
Court will find violation of condition number 18 true. Let's move on to cause number 2022 CR 5998. State, what allegation are you proceeding on?
In Bear County, Texas, the defendant Jalen Michael Collins did then and there failed to attend and provide verification of sober support / Alcoholics Anonymous / Narcotics Anonymous meetings for the month of January 2025 as directed in violation of condition number 15.
How do you plead to that? True or not true?
Judge, on that case, it was 5993, not.
Oh, I'm so sorry.
Just want to make
Thank
sure that
you.
it's clear.
So it's 2022 CR 5993. All right, to the violation of condition number 15, how do you plead? True or not true? State.
Waives the remaining violation allegations, Judge.
No objections.
All right, did you understand by pleading true to violation of condition number 15, court could find it true, grant the motion, and sentence you up to 8 years in the prison? Knowing that, do you still wish to plead true to violation of condition number 15?
Yes, ma'am.
Court will find violation of condition number 15 true. Is there proposed agreement?
There is not an agreement.
State, what are you requesting?
Amend conditions for status followed by aftercare, more recognition therapy, weekly reporting for 90 days, twice weekly delays for 90 days after completion of aftercare, enrollment in Project Quest, and residence in a sober living facility for a minimum of 1 year.
All right, and defense, what are you asking for?
Judge, Mr. Collins would like to address the court on a couple of issues, Judge.
Sure, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
My name is Mikael Collins. And
Well,
Mikael Collins.
all right. So why are you not doing your sober support meetings?
I was doing my sober support meetings, ma'am.
Did you provide proof?
I did not provide proof, ma'am. I had gotten robbed from my paperwork. I had gotten robbed from my paperwork and my phone. That is also why I was able to get the hotline. I was homeless at the time of these all this was happening when I first got out. And
Well, no, I mean, you've been on probation and I gave you deferred. And then there's a motion to revoke your probation. So this is is this a second motion to revoke or third motion to revoke?
Second, Judge.
All right, this is your second motion to revoke. And all of it is about you doing drug testing. It doesn't appear to the court that you are appropriate for probation.
I was still submitting drug tests for my probation officer after that, and I was passing my drug tests.
Is this true?
Judge, I don't have any indication. The last drug test we have is March, well, that was a no-show. Last negative was January.
Yes.
In January, I was reporting, and I was still taking my drug tests. The hotline, my phone and my paperwork had gotten stolen multiple times.
Mhm.
And that is why I didn't report to the hotline. I talked to my probation officer about this. We communicated about this, and also me trying to get myself back on my feet at the time, and having to report to the hotline and take a drug test every week, plus a random drug test. A job is really difficult that's gonna carry those stipulations off for a random drug test is very hard to keep. I would also like to say, ma'am, that I'm hoping community because I have a 5-month-old son and a 5-year-old daughter that
I don't know why people don't think about these things when they're picking up cases that they have children to support. Because you say your child is 5 and what else?
5-year-old daughter and a 5-month-old son.
All right, so 5 years old. And that means that you were placed on probation in 2023, correct?
Yes,
So if you do the math and you have a 5-year-old, that means that 5-year-old was in the world when you committed these offenses.
yes.
Okay. So why were you not thinking about your 5-year-old at that time when you were committing these offenses? That's what people do. People tend to come in and want to use their children as sympathy points when they were in the real world. I'm sure their children did not see them for birthdays. They were not taking their children to the parks, taking them to school and reading books. They were committing offenses. And now when it's probation time, that's when people want to bring their children out. It's similar to when people have done nothing to support their child through their school years, but the next time when their child walks across stage, they want to tell everybody and their mother, that's my baby. Or when you see all these celebrities who they say their father was never in their life, or either you see these people who are now basketball stars making millions of dollars. Here comes the no account father, no account mother who wants to say, that's my baby. I've always been there for them. And the child wouldn't even be able to pick them out of a lineup. And so now you're coming to me for sympathy because you have a 5-year-old and a 3-month-old. And I don't even 3-month-old. That means that in your situation where you're struggling, you decided to bring another child in this world that you cannot financially support and you don't have your life together. You did that. And are these children have the same mother?
Yeah.
All right. So she knew what she was doing. I don't understand it, but that's where we are. I don't think you're appropriate for probation. I'm not going to continue on probation. So does anybody want to speak to sentence? I'm going to revoke him in each cause number.
Judge, we would ask the court to minimize the prison time.
All right. This is what the court will do. And each cause number, the court is going to revoke. State, what are you asking for time?
8 years, Judge.
You go from 8 years to wanting him to be continued on probation? I mean, well, these are questions I'm asked. I'm just wondering what the thought process is because y'all say you want him to be continued on probation. I'm saying it's not appropriate. And now we're at 8 years. All right, why are we at 8 years?
That is his underlying sentence, and since Mr. Collins does not seem to be motivated to solve whatever problems that he has, the underlying sentence seems appropriate given the circumstances.
All right, in each cause number, the court is going to sentence you to 4 years in the prison, give you credit for any time served. The court will recommend the therapeutic community. And let me see if there's any restitution. All right, and both cause numbers will run concurrently. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? And did you sign it in each cause number?
Yes.
All right. You do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on community supervision. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. We can go off the record. Here's the thing with regards to the therapeutic community, you're going to have to request it. I have no jurisdiction over them to force you into the program, but you do have a drug problem. It's clear to the court that you have a drug problem. I've tried to help you solve that. You didn't take advantage of it. Once you're released from prison, if you cannot find a place to help you maintain your sobriety, come back here. If I'm still here, I'll pick up the phone, call the place that can help you. You understand?
Definitely.
All right, good luck to you.
Um,
Yes.
What's it called? I was gonna ask, ma'am, did you say I give my back time to?
Yes, you'll get credit for any time that you serve.
Thank you.
You're welcome.
Maybe excuse Judge. Maybe-
Yes,
Thank you. Judge.
yes. Okay. Good. All right, the parties on Douglas Cup. Court is calling 2025 CR 0027554, State versus Douglas Cup. Can I have parties announced?
Warren Wolf for Mr. Cup.
And are you Mr. Cup?
Yes, I am.
Counsel, have you received all discovery? Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Probation, this is an application. Mr. Cup, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, Your Honor, I did.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
That's good.
Mr. Cup, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor, I did.
By indictment, you're charged with possession of a controlled substance, penalty group 1 grams to 4 grams. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
All right, off the record. Are you all in agreement with his receiving probation?
Yes.
Any objection to the court checking that box?
No.
All right, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this agreement you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Cup, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
I did, Your Honor.
According to the plea, punishment is to be assessed at 6 years in the prison. There's a $2,000 fine. State recommends community supervision. This will run concurrent with 2024 CC 738359. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No.
Outside the agreement, the state is requesting that your community supervision be for a term of 6 years. There be a top evaluation and 200 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence.
Contained in Exhibit 1 and attachments, Judge.
No objection.
State you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it?
Yes, Your Honor.
Did you sign it in all the appropriate places?
I did, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. All right, so what's happening with all of the other things that were found in the vehicle, the body armor and the gun?
The gun is part of the plea bargain, Judge, and we need to go down to County 11 after we're finished here as part of the plea.
All right, and also the body armor? Okay, all right, thank you. All right, so do you have any children?
I do.
What are their ages?
18, 17, 15, 12, 1.
And do you have contact with them?
I do.
Do they live with you?
Yes, my, their grandparents right now.
All right, so that means that you're not taking care of them. It's the grandparents. Are they, are they the paternal or maternal grandparents?
Mother or father?
Father.
Okay. So basically you continue to have children and they're taking care of them. Is Child Protective Services involved in your life? Where's the mother of the children?
She's not in the picture.
She has a 1-year-old and she's not in the picture.
It's not the same.
All right, so that mother, where is she?
She's actually incarcerated.
All right, so the mother of the 1-year-old is in prison or in jail?
No, she's here.
All right, in jail.
No, she's not. Not the 1-year-old. I have 4 with one with the previous
Okay.
and 1 with my new spouse.
Oh, and so she's here today? Where? Oh, where's the 1-year-old?
She's with family.
All right, so basically the mother's raising children. I never,
That watching her judge.
all right, so I never understand. And who is this young person here in the courtroom?
That's my son.
All right, how old are you?
17.
All right, what are you doing with your life? Are you in school or not in school? Graduate? What are you doing? All right, why are people bringing children down here to see somebody who is in jail for drugs like this is somebody that people should be looking up to when he should be in school? Is school out? Is this an excuse day for him to come down and see this person be sentenced? Is he excused from class? Is he missing math? Is he missing science? Is he missing English literature? Why is he here? Why would you bring your child down here to see him be sentenced for committing a crime that your son should not even be around because he's committed a crime, and according to the police report, he's a gang member? This is somebody that you think is the great person to put in your children's life. I don't understand that. He should be at school. He's missing class. Why are people just staring at me like I'm saying something that is unheard of? Do children not go to school anymore? He's getting behind because he's here in court to watch this person get sentenced. And he should be at school studying. What are his grades? Is he doing well in school? Is he doing any extracurricular activities? Did he tell his teacher that he was going to be out because he's here to watch him get sentenced? Is this his biological father? Yeah. So why is he in school? And you should have told him, don't come down here. You need to be in school. I don't understand that. And then what ends up happening? People drop out of school and then they come in, and you know what they come to court and tell me? Well, you know, my father's been to prison. My father did drugs. My father's a gang member. And all these mothers are out here holding these men up as paragons of society for their children to look up to. And then having children with them that are one. Knowing their history, I do not understand that. But he's too young to be in court. And if people want to visit him, I know they don't do person-to-person jail visits anymore. You can only do it on phone. That's where he needs to see him. And when you get when you're out of custody, spend time with your children instead of just having them show up and want to be in their life when you're in court and you need them for sympathy. So he can step out of the courtroom. Thank you. So they have you listed as a gang member in here. What's this about?
For a small period of time, I was in a motorcycle club.
No, it says Bandito's gang member.
It's a club, Your Honor.
All right. When's the last time you had employment?
I'm self-employed.
Doing what?
I move mobile homes. I have a trucking company.
All right. And is that registered?
Yes, it's an LLC.
All right. This is what the court is going to do. The court is going to find you guilty, sentence you to 6 years in the prison, suspended and probated for 8 years, regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. I'm going to want a gang evaluation done. So when's the last time you used?
Your Honor, I don't use.
All right, so these drugs that were in the vehicle belong to somebody else?
Yes, they do.
The mother of your children?
Yes, they do.
All right, so, and that's the lady here, another one?
Oh, yes, my wife,
Oh, so you have your wife and your girlfriend.
my ex-wife, Your Honor.
And so recently you were with your wife.
Long story.
Oh, I know it's a long story. So you're cheating on your wife with your girlfriend or your girlfriend with your wife, and she's here for you. But okay. What's your wife's name?
Jaslyn Pettis.
Jasmine Pettis?
Jaslyn.
Jaslyn. There's to be no contact with Jaslyn Pettis.
Sorry.
Yes.
That's his current,
Oh, that's the current girlfriend.
correct.
Who
The
is your
former
wife?
girl is,
Or is she just your girlfriend?
Jessie Solis.
Is that just your girlfriend or did you all get
That's my
married?
wife. We got married.
All right, so no contact with the wife, Jessie
Solis.
Solis, that he is still currently in a relationship with. That's why it's in her car with her drugs. So tell the girlfriend he's still in a relationship with her. And, you know, that shakes out the way it shakes out. Either she's the number one girlfriend or not. That's what he's doing. So no contact with Jessie Solis, no unsupervised contact with minors. UA hotline. Field visits 1 time per month until further notice. 200 hours of community service restitution. The court is going to order parenting classes Once the parenting classes are complete, community service hours will be deemed satisfied. TAP evaluation, in custody, follow results. Is there anything else, probation? Is there anything else you need from the court in order to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
I did, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. And also, this will run concurrent with 2024 CC 738359. All right, we can go off the record. Let me just tell you something. Probation is very difficult. And if you are going to have a wife and a girlfriend and you're secretly still in a relationship with both of them, your probation is going to get very difficult, even more difficult. You know why? Because if something goes on in your household where there's an argument, you're cheating, and you're not letting them know, you know what's going to end up happening? They're going to call your probation officer and you're going to be reported for whatever issues are going on in your household. So you're going to have to make a decision so your children are not confused. Either you're going to be with your wife or either you're going to be with the new girlfriend. For some reason, the new girlfriend decided to hang her moon and her stars on you. So you're going to have to be a better person. You understand?
Yes, Your Honor.
In order to be successful in this court, communication is key. Let probation know if you have any issues. If you feel they're not addressing it, you can always come back to court. You understand?
I do, Your Honor.
All right, good luck to you.
Judge, we need to go down to 11. The
Oh,
bailiff
the
can,
the deputies are in charge of that.
I just wanted to. put
Thank
that-
you.
After they're done.
Okay.
Gabriel H. Ortia,
Thank you.
you're welcome. Are y'all ready to proceed on the motion to revoke?
We are, Your Honor. Yes.
Court is calling 2024 CR 1497 State versus Gabriel Paul H. Ortia. Echatea. Sorry.
It's okay.
Could I have parties announced for the record?
Jason Garrett, State Your Honor.
Jesse Sepulveda for Gabriel Echartea.
And are you Gabriel H. Ortia?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it? Are you the same Gabriel Paul H. Ortea who was placed on deferred adjudication in 2024 CR 1497 for the offense of evading arrest or detention with a vehicle on June 17, 2024 for a period of 2 years? All right, state.
Yes, Your Honor, violated condition number one, on or about the 13th day of February 2025, in Bear County, Texas, the defendant Gabriel Paul Echeverria committed the offense of reckless driving and violation of condition number one.
How do you plead to that, true or not true?
Your Honor, we'll waive the remaining violations.
Any objections?
No objections, Your Honor.
Did you understand by pleading true to violation of condition number one, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number one? Court will find violation of condition number one true. Is there a proposed agreement?
There is, Your Honor.
Yes.
And now the motion to adjudicate and continue the individual on his deferred and have it amended to include local ISF 2 and wait for jail for placement and monthly UA for 6 months and amend for IOP as recommended by the TAP. And the state will take into consideration clause number 2025 CC 002773, which is the reckless driving he just pled true to.
All right. Is that the agreement?
It is, Your
Are
Honor.
you asking the court to follow that agreement?
We are, Your Honor.
All right, can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. How old are you?
21.
You're 21. You want to go to prison? Do you want to be over in the box with those gentlemen over there? Some people at the jail, people at the prison, they're charged with murder, right?
Yeah.
They're charged with sex offenses. They're charged with robberies. They've been to prison before. This is their third time or whatever. It appears to the court that maybe that's where you want to go. Because you're not doing what needs to be done. You're here on an evading arrest with a vehicle. You live with your parents. I can't even believe they're still allowing you to drive. You shouldn't even be driving. Because obviously you're not mature enough to drive. And this reckless driving, what was that about? No. I didn't ask you whether you made a bad judgment or not. We know you did. That's why you're here. What is it about? How were you driving recklessly? Were you going beyond the speed limit? Were you out here, like I see these children do, shutting down in the street, doing, roundabouts? What were you doing?
I was going over the speed.
By how much?
Not too sure. You didn't say on the report.
You should know.
According to the report, Your Honor, I think he turned off his lights and he passed a few stop signs. They said he was driving at a high rate of speed, but they didn't say exactly.
So let me
how
ask you
fast.
this. Let's think about this logically. You're young. Sometimes young people don't think logically. You turn off your lights. I'm assuming then this was nighttime.
Was.
You turn off your light at nighttime and you're blowing through stop signs. What do you think the purpose of a stop sign is for?
You stop the vehicle.
But why? Why do we have stop signs? Why do we even have red lights?
In case of pedestrians coming through or cross traffic.
And why, when it's nighttime, why do you have to have your lights on?
So another vehicle or a person can see the vehicle.
So if you turn off your lights, what does that mean? Will people be able to see you? All right. And then somebody is walking past that stop sign because they don't see a vehicle. What's going to end up happening?
Collide with the person or
Uh-huh.
vehicle.
And what's going to happen with that person?
They either die or get seriously
Yeah.
injured.
And let me just tell you what would have happened if you would have hit someone. You would have ended up hitting that person, and you know what you would have done? You would have left the scene. They would have ultimately found you, and then you would have been in the box, and you would have been before me crying, asking for tea and sympathy. So what I can tell you is this. The only reason why you're not going to prison right now is because your age, and I guess you're not thinking. So I'm going to try to help you think and make better decisions. So I'm going to deny the motion. I'm going to alter him in conditions. He will be taken into custody today. He's going to local ISF. And since your family won't do it, I'm going to have to do it. You are not allowed to drive. Wherever you need to go, either you're going to have to get an Uber, you're going to have to learn to do the VIA. You're not going to be driving for the rest of your probation. Don't come back to me saying I have to go to school in another county. You're going to have to figure it out. Do you understand? And I will take in consideration 2025 CC 002773, and we'll do a referral to felony drug court. And all of that is to take place in custody. And then you said intensive outpatient treatment?
Oh, no, actually, inpatient.
Inpatient treatment? Oops, sorry.
Oh, I'm sorry, Judge, you're right.
Yes.
You got the other part.
All right,
Yes,
so
Your Honor.
that'll be inpatient treatment. And I know that you all didn't go on the section about using marijuana. It's illegal in Texas. You're on probation. You're not allowed to use marijuana. If you want to sit around, fry your brains or whatever, you can't do it while you're on probation. Do you understand? And we can go off the record. What are you planning on doing with the rest of your life?
Join the military.
All right, well, the military, they're not just accepting everybody. And counsel, once he completes all of this,
Yeah.
if he signs up for the military and I need to see it signed on the dotted line, I will let him go.
Thank you, Judge.
Thank you.
Will we be excused?
Yes. Rico Silva and Deputy Laura. Oh, it's been dismissed. Deputy Laura, I'm gonna do Mr. Burnell, and then everyone else can go back for the afternoon.
Mr. Brunel is not a.
I'm sorry, Mr. Silva, and then everyone else can go back for the afternoon.
Thank you, Judge.
Oh, that's fine.
And just a reminder, this is the one where he had a different attorney out of county for 5 months. He
Yes.
never spoke. Okay, we're ready to proceed.
Okay. All right. Court is calling 2025 CR 001052, State versus Rico Silva. Can I have parties announced for the record for the state?
In Galloway for the state.
Joseph Stateson standing in for Monica Guerrero and Mr. Silva. Will you give me permission to do this in place of Ms. Guerrero? Speak louder.
Yes, sir.
All right, counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Are there any applications?
No, Your Honor.
All right, Mr. Silva, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, the state moves to proceed on the lesser included offense of attempting or unlawful possession of a firearm by a felon, the state jail felony.
No objection.
All right, did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand the state is proceeding on the lesser included offense of attempted unlawful possession of a weapon by a felon? As a state jail felony, range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
Court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Ricke, has anyone threatened you, forced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand that?
Yes, Your Honor.
According to the plea, state is proceeding on the lesser included offense of attempted unlawful possession of a firearm by a felon. Punishment is to be assessed under 1244. Is that correct?
Yes, Your Honor.
Yes.
At 1 year in the Bear County Jail. There's $1,000 fine and no applications. Did you understand that to be the plea?
Yes, Your Honor.
Defense is at the plea.
Yes, Your Honor.
State is at the plea.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counselor, have there been any such motions?
No, Your Honor.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offers states one in attachments.
No objection, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, we ask that you follow the plea bargain agreements.
All right, the court will sentence you to 1 year in the Bear County Jail under 1244, give you credit for any time served, and there will be $1,000 fine, time, and money to run concurrently. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. You're gonna have to make better choices. Otherwise, you're gonna find yourself in prison for the rest of your life. Do you understand? All right, do better. Good luck to you.
Thank you.
You're welcome.
Thank you, Judge.
Court is calling 2025 CR 0027763, State versus James Charles Webb Jr. Do I have parties announced?
Fair saying with the state.
Orlando Castañon for defense.
And are you Mr. Webb? Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Webb, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
No, Judge. Waiving count 2.
Any objection?
No, Judge.
Did you review the admonishments with your attorney? Did you understand it?
Yes.
All right, you have a lot of bass in your voice. You need to speak up so the court reporter can hear.
Okay.
All right. And did you sign it in all the appropriate places?
Yes, ma'am.
All right, and count 1, you're charged with possession of a controlled substance, penalty group 1, 1 to 4 grams. That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Believe so.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Webb, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, state is proceeding on count 1. They're asking that your punishment be assessed at 4 years in the prison and they're recommending community supervision. Did you understand that to be the plea?
So you understand they're recommending probation, community supervision?
Yes.
Did you understand that to be the plea?
Yes. Yes, sir.
Defense, is that the plea?
It is, Judge.
State?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Judge.
Outside the agreement, the state is requesting that your community supervision be for a term of 4 years and there be a TAP evaluation. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense as charged in count 1, how do you plead? Guilty, not guilty, or no contest?
Guilty, Your Honor.
Any evidence?
Containing exhibit and attachments.
No objections.
All right, state, you may be excused. Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Just that we ask that you follow the agreement, Judge.
All right, do you have any children?
No, ma'am.
How long have you been using?
I honestly don't use, I just, to be honest with you, Your Honor, I have.
Please be honest.
I had lost my sister
Mhm.
and, I don't deal good with stuff like that. So it was just, that's what happened. And I used because I didn't want to feel.
Right, see, I find this odd. And let me just tell you what I find odd. You're telling me this is the first time you've ever used.
I'm
And so I always ask people, if this is the first time you use, what is the thought process? Did you just go and find some people you knew who had drugs and bought drugs? That doesn't make sense to me.
I just wasn't thinking. It was a stupid.
No, here's the thing. You want to tell me you don't have a drug problem? That is fine. You know what's going to end up happening? I'm going to send you out into the world. I'm not going to give you any drug treatment because you're telling me you don't need it. You don't have a drug problem. If you end up testing positive, a motion to revoke is going to be filed. I'm going to notate on the docket sheet that you told me you didn't have any drug problem. So if you test positive and you come back here for drugs, I'm going to be like, no. You said you didn't have a drug problem. So why are you here testing positive? So now's your chance. Does your client have a drug problem?
Judge, he was caught with drugs. I think that he may be in the process of needing to accept accountability for his past actions. I don't know whether he has a drug problem or not. He's indicated to me that he does not.
No, it says they searched him. He's like, I might have some meth in my backpack. So I'm going to ask you for the last time. And then after this time, I'm not going to ask you anymore because you're saying in all honesty. And what can I tell you? Usually when people come to me and they say in all honesty, what they're about to tell me is not in all honesty.
May I just have a moment?
Sure.
Step back. Judge, I've spoken with Mr. Webb, and I believe that
it's probably not the first time I've used drugs, and I'm.
Well, I
pretty
don't even
sure-
know why you're throwing in the qualifier. It's probably not the first time you used drugs unless you've lost your memory. Either it's the first time you use drugs or it's not.
No, ma'am. It's not.
All right. And so what have you been using?
Well, just marijuana and methamphetamine.
All right. And you used meth more than once?
Yes, ma'am.
All right. So I don't even understand why the dishonesty. Obviously, the state wants you to have probation. If I'm going to give you probation, I want you to be successful on it. I take no joy in sending people to prison.
I'm my apologies.
What is your criminal history?
I have not really too bad. I have
Any criminal history is too bad. You shouldn't have any. So let's start, elevating our thinking
yes, ma'am.
that any criminal history is bad.
Yes,
You can say, you know what? This is the criminal history I have. I'm trying to improve myself. All right?
yes, ma'am.
So what's your previous criminal history?
I have a card with marijuana. I do have mostly marijuana, theft or evading. Nothing too extensive. This is
Anything is too extensive.
yes, ma'am.
All
I'm
right.
sorry.
No.
I don't believe you have any violent.
No,
criminal
I'm not a
history.
violent person at all. I'm a God-fearing person, honestly.
All right, dude.
But I messed up.
Oh, thou shalt not steal.
Yes, ma'am. Yes, ma'am.
All right. So do you have any gang affiliation?
Oh no.
Who's your support system?
Older sister and God, and that's about it.
All right. And you're telling me you do not have any children?
Oh man.
All right. That's a good thing. How far did you go in school?
I have some college. I have an associate's, and I have a whole bunch of like trades and stuff like that.
All right. What are you planning on doing with the rest of your life?
Well, I want to become like a counselor, honestly, for the youth. That's
Well, you need
ultimately
to
my
work
goal.
on that.
Yes, we do.
All right. Court is going to find you guilty, sentence you to 4 years in the prison, suspended for 4 years, regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days of release, no employment as a home health care provider with minors. TAP evaluation and referral to felony drug court, that can be done in custody. What will end up happening, felony drug court will be able to see him before the week is out. Be honest with them. It's a tough program, but it's a good program, and they will help you get your life back on track with employment, with, your college or whatever you're planning on doing. You understand? There's going to be 200 hours of community service restitution. If you obtain some type of trade school certification, or if you obtain your bachelor's degree, community service hours will be deemed satisfied.
Yes, ma'am.
And do you have a place to live? All right, so they're going to be field visits for 8 months, and it'll be once a month. Probation, is there anything else he needs? All right, and I'm going to do 60 sober meetings in 60 days. That's your AA meetings, but they call them sober meetings now. All right, do you need anything else from me to be successful?
I have a quick question.
Sure.
How long do you think it would be until I would be released
Oh, felony drug court will see you this week.
this week?
Yeah, they'll probably see you this week. They have a quick turnaround on seeing everybody. At the latest, maybe Monday. And the reason why I say that, because Friday's a holiday. It's Good Friday. So I know the courthouse is closed on Good Friday here. I know in some other counties, maybe not, but here in Bear County, they close it. So at the latest, they'll see you on Monday and you'll probably be released on Monday. But if, all right, that's why I threw in felony drug court. So if you're honest with felony drug court, I know that felony drug court will accept you. It's a hard program, but it will be perfect for you. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand?
Yes, Your Honor. Can I,
Mhm.
be honest with you real quick?
Sure.
Um,
Well, I mean, are you being honest with me?
yes, Your Honor.
Yes.
I have I'm like my girl's primary source of income right now, and I really, really need to get out as soon as I
Okay,
can.
let me ask you this. Why are you her primary source of income?
I'm all she has as well. And
Well, doesn't she have a job?
she came with me, and like I said, I flew out here when my sister got sick and she passed away, and I haven't even got to go and
Where's her family? We can go off the record. Where's her family?
she doesn't have any family either.
Oh, no, people have families. Sometimes people burn bridges with their family and their family are just done with them. Maybe her family said, hey, if you want to go to a city where none of our family is and follow this guy who has these criminal charges, that's on you. We don't recommend that you do that. Now these are called consequences. So she probably needs to pick up the phone, call her family and said, I made a mistake. If she thinks she made a mistake, or either she's going to have to get a job and support herself. So,
May I be excused, Judge?
yes.
Thank you.
And ladies and gentlemen, Judge Boyd finishes it off with another good nugget. I don't know what's happening right now. Oh, there I am. Oh my Lord. I was lost. Right now we're going to the first of our two court systems that were not closed on Good Friday. That's Kansas with Judge Ricke. We're going to check in on somebody we were seeing in February who is here for kidnapping and hear from her victim. And it all starts right now.
Sincere Scott, case number 2024 CR 346. Amber Norris appears for the state of Kansas and the Butler County Attorney's Office. James Watts appears as defense counsel. The defendant, Wendy Scott, appears from the detention center's Zoom location. This matter comes before the court at this time for sentencing. Court's docket notes indicate that Ms. Scott appeared before this court on February the 21st, of 2025. At that time, the defendant pled no contest and accepted conviction for count 1, apparently as amended, kidnapping, a level 3 person felony, count 3, criminal threat, a level 9 person felony, and count 4, aggravated robbery, a level 3 person felony. A pre-sentence report was ordered and sentencing set for today. Court has received a pre-sentence investigation report compiled by Jessica Morgan, pre-sentence investigator, who is present on this meeting with us. I trust each attorney has received a copy of this report, and I'll ask the state's attorney first. Is there any objection to the criminal history as stated in this report?
No, Your Honor.
Is there any objection by the defense, Mr. Watts?
I've reviewed it with my client, Your Honor. We believe it is correct. Have no objection.
The court will adopt the criminal history as stated in the report and finds that the criminal history score applicable to the primary count in this case is criminal history score B, and the court will proceed further accordingly. Ms. Norris, do you know of any legal reason why sentence should not be pronounced in the Scott case here this afternoon?
No, Your Honor.
Mr. Watts, are you aware of any such legal reason?
No, Your Honor.
Ms. Scott, are you aware of a legal reason or any other good reason why the court shouldn't proceed further with your sentencing today?
No, sir.
We'll proceed further then. Regarding sentencing related motions, this court is aware there has been a motion entitled Motion for Durational Departure submitted by the defense. The court has a copy of that before it. Mr. Watts, you may proceed further in regards to this motion.
Thank you, Your Honor. Your Honor, I'm not going to go through the entirety of the motion. The written motion is there, and I'm sure the court has read it thoroughly. I want to speak only to basically a couple of parts of it. As I noted in the motion, this is a case that my client, and as I've noted right from the beginning, my client knows full well this is not what a court wants to hear at a time of sentencing. I've heard Your Honor in other cases specifically speak to this very issue, so we knew what we're kind of getting into when we say it. My client has argued from day one and alleged from day one she did not commit this offense. That continues to be her position. And that continues to be her position despite the plea entered in this case. And I will focus only on a couple of things as part of that. I had occasion to have a phone call. The most important part of this is Sierra White. Sierra White was a person over in Wichita who I spoke with on the phone at one point. Ms. White told me at one point during that phone call that a car came by, the car that was stolen in this case, and picked Ms. Scott up, that Ms. Scott had been with Ms. White during that time. However, I know full well that me relating a phone call to the court is not admissible in court. There's no way that by itself is going to be sufficient. I spent 5 months with a private investigator attempting to locate Ms. White. And it's just very clear that over the course of that 5 months, Ms. White did not want to be located. The private investigator had occasion to go to her house, speak to, if I remember correctly, a daughter, but Ms. White was never there, was never where she was said she was going to be. My investigator spent, I don't know exactly how many times, but 5 months of attempts to contact Ms. White. And as I made it clear in the motion, Ms. White apparently didn't want to be contacted for a couple of reasons. One, she had apparently had a warrant out. I, of course, as in my circumstances, don't care at all about the warrant. That's not my concern. But the other is in the world that Ms. White lives in, and to a certain extent, the world that Ms. Scott lives in, I'm certain, is not the same world I live in and perhaps you live in, Your Honor. In Ms. White's world, police are not to be trusted. Police are not to be, authorities are not to be cooperated with. That is not assistance, that's betrayal. So Ms. White was unable or unwilling, maybe a better way to put it, unwilling to come forward. Without that confirmed witness, which would have been an alibi witness had she been able to come forward, had she been willing, maybe put it more accurately, had she been willing to come forward, the this case was simply not viable to try. I discussed that with Ms. Scott, and she made a determination that she did not want to continue to find Ms. White to continue to pursue a defense, but rather would simply resolve this case by plea. In doing so, she saved the state and the court significant time. She gave up not only the ability to defend this case in court, but in any realistic sense, the ability to appeal it as well, as I discussed with Ms. White. So, as I said, I'm not going to go completely through the motion and not going to get into details, but I thought that needed to be spoke to. And as I started from the beginning, my client and I understand that is not what courts want to hear at time of sentencing. It is, however, the reality, Ms. Scott's position in this case. Frankly, I don't know, had we been able to secure Ms. White's testimony, how this case would have gone. That is speculation. Had her testimony been consistent with what she at one point spoke to me on the phone, there may have been an alibi witness and a viable alibi witness. But given the certain reality, that was not possible. One of the bases for a departure is that there was a valid and defensible witness, valid and viable defense, even if a jury did not accept it. Now, this is not that case where a jury did not accept a defense. This is a case where the defendant was unable to put on that defense because the witness necessary to that defense was unwilling to come forward. For those reasons, and again, I'm not going to get into the rest of the motion at this point, we would ask the court to consider a durational departure in this matter, if not a dispositional one. I'm not asking for a dispositional departure, but a durational departure in this matter. Thank you, Your Honor.
Mr. Watts, a question from the court. Even if this Sierra White could be located and testified in the manner in which you described, that she saw Wendy Scott being picked up in the stolen vehicle, that doesn't mean necessarily that Ms. Scott wasn't involved in the original taking of that vehicle, because this obviously would have been much later than the actual taking. True?
No, Your Honor. It is if what Ms. Scott also told me that she had been with Ms. Scott that day and had been with Ms. Scott all that day. It was picked up later that day. If that is in fact the case. Now, again, I have no way to know if that's the case because she was unwilling to come forward and be interviewed and take part in this case. We believe this would have been, again, were we able to interview her and were she able to come forward? This may have been an alibi witness. We can never know that with any certainty, of course, because she was unwilling to come forward.
Very well. Anything further on the departure motion, Mr. Watts?
No, Your Honor. The motion speaks for itself as to the remainder.
All right. Does the state wish to make argument in regards to the departure motion currently before the court? Ms. Norris.
Your Honor, keeping with the plea negotiations, the defendant was allowed to ask for departure, but there's no agreement, and nor was the state required to join necessarily. Your Honor, I find the bulk of the motion to not even really sure what to call it. It seems like maybe a work of fiction. There was no trial. This motion is the first I've heard of any alibi witness. None of that information was ever provided prior to this motion. And I really think it has zero bearing on the sentencing at this point. The defendant pled. And we negotiated the plea. Again, none of this was ever talked about. I feel, or the state's view of this, along with some other issues in this motion, is that, and defendant actually pled no contest, is that the defendant is unwilling or possibly incapable of taking responsibility for any of her own actions. So like I said, she pled no contest. Now we're having a discussion about a possible alibi witness, which is irrelevant at this juncture. And I would also note let's see, I guess it's bullet point number 7, that she apparently has told her attorney that the reason, she's B is because of this flee and elude aggravated battery from 2020, which is 5 years ago, which is not that long ago, that she was a passenger, and that, basically, we don't even know how she ended up actually being charged. Well, that is completely inaccurate. She was the driver. She fled from law enforcement and she hit a police officer while she was fleeing. And that's directly from the official version in the PSI from Jackson County regarding the case and the conviction. So she's obviously, I assume that she told Mr. Watts that, she was the passenger and that she wasn't responsible for any of that. And so that's what he put in his motion. And again, back to not taking responsibility for her actions. So, Your Honor, I would ask that the court deny the request for any form of departure. We basically had spoken that we would recommend the mid-box presumptive sentence, and that and so we would be requesting that the court follow along with that plea negotiation, which is what we previously discussed. And does the court want recommendations at this point additional to that? And I also wanted to let the court know that the victim and a member of her family would like to address the court as part of sentencing today too.
Ms. Norris, the court will take up the state's formal recommendations a bit later in this proceeding.
Thank you, Your Honor.
All right. Having heard from both parties on the departure motion, at this time, the court will ask, does the victim or any member of the victim's family wish to address this court in relation to the Wendy Scott sentencing? Ms. Zielke, I see Zielke on the screen. You're muted currently. So if you'll turn on your audio and then you can make your statement to the court.
Can you hear us now?
I can hear you.
Okay. Now what?
Ma'am, I'd first ask you to state your name.
Beverly Zielke.
Do you have a statement to make to the court?
I sure do. I'm the one they threw in the road and drove off in my car, my brand new car.
Okay.
That
All right,
still
ma'am.
had a paper tag on it. I never even had time to get a tag yet.
What do you want to say to Wendy? To Wendy.
Am I to speak to her
Yes.
now
You,
or what?
you can make whatever statement you feel is appropriate.
I cannot believe she did what she did. They played me for a fool. She was a neighbor. Her other friend was a neighbor. And she showed up at my house. I'd never met her. And she said, is she here yet? And I said, here? And she named the other girl. And I said, no, she was coming to borrow a cookbook. And she said, can I come in and wait for
You're talking to Wendy. Wendy, not.
Let's let Ms. Zielke make her own statement, please.
Am I doing it wrong? I've
No,
never
you're-
been to court, so I don't
You're doing
know.
fine, ma'am. I just don't want anyone else saying anything in the background or anything like that. I want you to make the statement, Ms. Zielke.
Well, I am.
Okay, go ahead.
And she took, and then she started rolling on the floor and Wendy said, could you take us to the emergency room? She's having a bad time. And I said, well, yeah, I can take you. I can't go in because I'm babysitting my daughter's dog because she took a cruise and I'm babysitting. So we got in the car and Wendy sat in the back seat. The other girl sat in the front seat. And they had me turn, when you go to Andover, I thought we were going to Andover, and she said, no, turn, it's two roads before you get to Andover. And I drove on a country road, and I drove and drove and drove and drove and drove. And I said, where is this place you want to take her to because she started, when she was in my house, she started rolling on the floor and saying her stomach was killing her. And Wendy says, oh, she needs to get to the emergency room. Could you take us? And we drove and drove. And I finally says, how much further is this place? And she said, we're almost there. It's not too much further. And I drove and drove. And then I finally stopped the car. And I said, well, where is this place? We've been on the road a long time. And she held her purse up and she said, see this purse? And I said, yes. And she said, I have a gun in it. I have used it before and I'm sure not afraid to use it again. And then she yanked my car door open and she started pulling my arm, and the other girl was in the front seat on the rider's side, and she was pushing me on my back trying to make it. I was hanging onto the steering wheel and trying to stay in the car, and they were yanking and pulling. And Wendy had long fingernails, and they were painted, and she kept pulling on my arm like this, and I had, her nails went through my skin from here clear down to my wrist. My whole arm was bleeding because her fingernails had went all through my skin, all around my arm, because she was trying to pull me out of the car. And she finally won. She pulled me out, and I had my daughter's dog in the car with me, and I didn't know if they threw me down in the dirt, and the dirt, my whole arm was black because it was bleeding with blood from top to bottom. And I was scared I was going to die because she threatened me with a gun. And it scared me to death. And after they threw me in the dirt on the country road, they took off, and they had my purse. They spent $1,000. They used a credit card. I think they bought gas. And I had to walk. I walked to one place and they weren't home, and I walked another down in the next mile. And I finally came to a family that was home, and they called the police. And then the sheriff and the police and the fire station, the truck all came. They wanted to know if I wanted to go to the hospital, which I said no. But they cleaned my arm and disinfected it. The whole arm had her fingernails had gone through my whole entire arm. It was pure blood. And I was terrified. All I did was I was going to take her to a hospital because she said her stomach was hurting, and she's rolling on that mat floor back where the cookbook was in my house. The other girl. So I don't know. She never, ever, ever said out she's sorry. She hasn't to this day. I went through a lot of hell with that, and I've never done anything in my entire life. I've never been in trouble with the police in any way in my entire life. I couldn't believe all of this was happening. All I was going to do was help them. because she was crying and they asked me to take them to the emergency room. And I said, of course I'll take you to the emergency room. I don't know what else to say. You want to have a question for me?
Ms. Zilke, the court would just ask you, is there anything else that you wanted to say to the court today about Wendy Scott's sentencing?
I think she's the one that took my car and drove it. Was the driver. She took my car and pulled me out into the dirt. And I didn't know if they took little Chloe or not because I had my daughter's dog in the car. I didn't find that for another week. I thought she was gone. I thought they had taken her, but they didn't.
Okay, so was the dog recovered then, Ms. Zilke?
Yes, finally, yes. And they had a month later, it was about 3 weeks later, and a farmer that lived he was at their house, and they had made when you on the dog pound thing, they had a left message that there was a dog, and we thought it sounded like Chloe, and so we went there and it was Chloe. So we did get the dog back.
All right. Anything else?
I just I just can't believe that they did that. I just can't believe that she did that. They just threw me, and I'm 87 years old. I'm 87 years old. And they threw me in the dirt and threw me out of my car, out on a country road. I think she deserves to pay for something because I cannot believe she did. I can't believe anybody would do such a thing to anybody. I don't care their age. I can't believe they would do such a horrible thing. There was never anything bad to them. Everything they did was to hurt me. And I didn't realize that.
Ms. Zilke, thank you for your statement to the court. Just so we can eliminate background noise, could you go ahead and mute yourself again, ma'am?
Muted by.
Mute.
That one. Okay, are we muted?
Is it done now?
Not yet. Okay, I think you are now. Thank you. All right. I'm going to perceive here that there's no other members of the victim's family who wishes to address the court.
I think maybe there is, Your Honor.
Okay, then if it's the person who's with Beverly Zilke, if they can go ahead and unmute themselves.
Unmute. Okay, now say that again, please.
Are you a member of
Yes, I'm her
Beverly's family?
niece. I am her niece.
Did you have any
And I've had
statement that you wish to make to the court?
Yes.
All right, first of all, state your name.
Wendy K. Dwyer.
All right. Ms. Blyer, what is your statement?
Dwyer, D-W-I-R-E.
Okay, thank you.
Okay. All right, first of all, my aunt clearly remembers Wendy Scott's face and clearly remembers Wendy Scott being in the apartment. This is my turn. The reason I felt it was important to speak to Wendy Sincere Scott is because I want Wendy to truly understand how horrific the crime she committed with her friend Elizabeth really was. Wendy, the reason I feel you need to hear this is because every Zoom court I watched, you never was concerned about my aunt. You were very concerned about yourself like you are today. My Aunt Bev is 87 years old, and you never once stated you were sorry, and you knew there was a good chance she was watching those on Zoom, but you never had any remorse about what you did to her, and that tells me a lot about you. You totally made a plan with your friend Elizabeth, who happened to live in the same building previously, to reach out to an elderly lady about a cookbook, and then your friend following through with y'all's plan to create a medical issue to get my Aunt Bev into her car with the two of you. This was totally planned with no remorse or feelings about it. Then you threaten her by telling her you had a gun and weren't afraid to use it before pushing and pulling on her to shove her out of that car and leave her on a country road, and took off with the car, the purse, a dog, and then bought 4 cell phones with her credit card, and then go joyriding in the car with not a care in the world. The fear and trauma this has caused on my aunt is horrible. She has lost all trust in people and now lives her life in fear. What you and your friend did shows your character and who you are as a person, which is downright cold with no feelings at all. I hope you take the time away to reflect on your life and all the lives you have hurt along the way. I also hope your grandma, mom, daughter, aunt, or whoever it may be never has to go through this scary, traumatizing experience that my aunt had to live through and continues to deal with every day. That's what I had to say. I'm done.
Very well. Thank you, ma'am. If you'd go ahead and mute yourself again, please.
Oh.
All right, I see that they have muted themselves. So at this time, the court will ask for recommendations from counsel regarding an appropriate sentence. Ms. Norris, at this time, the state may make any formal sentencing recommendations.
Thank you, Your Honor. Regarding count 1, the kidnapping, would ask the court assign defendant to the mid-range guideline sentence of 216 months in the Department of Corrections. On count 4, the aggravated robbery, 59 months in the Department of Corrections. And regarding the criminal threat, 6 months in the Department of Corrections. Overall, defendant would be able to earn up to 15% good time credit and would be subject to 36 months of post-release. As previously discussed, this is a registerable offense, although defendant will not need to register while in custody, but upon release. She has earned 269 days of jail time credit as of this date. Your Honor, we'd ask the court assess the cost of the action to the defendant. The court will need to make findings regarding the court-appointed attorney's fees and the vids application fee. There is no request for restitution, and state is not requesting a fine as a condition in this case. Otherwise, Your Honor, I don't think state has any further recommendations for the court at this time.
Doris, what's the state's position regarding consecutive or concurrent sentences on the 3 counts?
Your Honor, in keeping with the plea negotiations, it does appear that we discussed concurrent mid-box, follow the presumption. And that was via email prior to the plea on February 21st.
Very well. Thank you, Ms. Norris. Mr. Watts, at this time, I would ask you as defendant's counsel to make recommendations regarding an appropriate sentence. Mr. Watts, you are muted.
Your Honor, as to count 1, we'd ask the departure to half what would the otherwise granted sentence for the reasons previously noted. I would note response to Ms. Norris, and I think something mentioned in court at the time we set the plea deal. We set not the plea, but the trial date where it was in February from a October preliminary hearing, in large part in order to attempt to find the alibi witness that the state believes is fiction. Moreover, I am not required, nor would I, inform a defendant of any potential alibi witness until that witness is actually secured. As to the matter in Jackson County, I understand that's the state's position. I have no knowledge of whether that's accurate or not. In any case, as to the aggravated robbery, would ask the standard mid-range. In that case, we'd ask they run concurrent pursuant to the plea agreement with count one. And as to criminal threat, the standard mid-range, and again, pursuant to the plea agreement, concurrent to count one as well. I don't think I have anything else to add, Your Honor.
Very well, Mr. Watts. At this time, the court will address the defendant, Wendy Sincere Scott, personally, and the court will ask her if she has any statements that she wishes to make in mitigation of punishment or anything further that she personally would like to present. Ms. Scott.
First off, I'd like to apologize. I never got the opportunity to apologize to Ms. Zilke under any of these crimes that was committed. Every time I was in court, I basically let my defense attorney talk for me. But from the bottom of my heart, what I was involved in, I do apologize for that because I know I was in the wrong and I was very drugged up, but I don't want no oh poor me situations like I explained to my defense attorney. It never was oh poor me. I do apologize to Ms. Zilke for everything that was committed, that she was harmed. But what I had something to do, whatever I did in the situation, I do apologize for that. And don't nobody should have to, go through anything like that. So that's what I like to, inform. And that's all I like to say, Your Honor.
Very well, Ms. Scott. At this time, the court will pronounce sentence. Ms. Scott, it would be difficult for this court to listen to a victim statement like made by Beverly Zilke and not feel some level of compassion for this elderly woman and what she went through. The actions of yourself and your co-defendant in the view of this court were utterly reprehensible. This is a woman who tried to reach out to you with kindness based on what she perceived was a legitimate medical issue. And in return, what she got in response was deceit, violence, and theft of her car. It would be difficult to imagine a more severe situation for these crimes than this. I think that we all should feel fortunate that Beverly was not hurt even more than what she was. But the court, considering all factors in the case, first of all, we'll just make a finding here for purposes of the record that the court, having considered the entirety of the motion for durational departure and all of the reasons which are stated and have been argued by Mr. Watts in this case, court finds that there are no substantial and compelling reasons that would justify a departure sentence in this case. With that said, the court hereby establishes count one as the base sentence for the offense of kidnapping, a severity level 3 non-drug person felony, in which this defendant has a criminal history score of B, thus placing her in grid box 3B. The court hereby sentences the defendant to a term of 216 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 15% of good time credit and would be subject to 36 months of post-release supervision. The court imposes no fine on that count. Regarding the additional offense of aggravated robbery, a severity level 3 non-drug person felony, in which the defendant has a criminal history score of I, thus placing her in grid box 3I. The court hereby sentences the defendant to a term of 55 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 15% of good time credit and would be subject to 36 months of post-release supervision. No fine is imposed on that count. Regarding the additional offense of criminal threat, a severity level 9 non-drug person felony in which the defendant has a criminal history score of I, thus placing her in grid box 9I, the court hereby sentences the defendant to a term of 5 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. Court imposes no fine as to that individual account. Ms. Scott, with this court's finding that this was a terrible, avoidable, reprehensible crime, this court will run the time on counts 1, 4, and 3 consecutively with one another. This court of the belief that each one of these offenses constitute a separate criminal and violent act involving Beverly Zielke. And therefore, each one should be punished separately, and the court will run all 3 counts consecutively with one another. Doing the math here, the 216 months on count 1 is run consecutively with the 55 months on count 4. That would add to 271 months. There is an additional 5-month sentence on the criminal threat, which makes a total sentence of 276 months in prison. Ms. Scott, the primary controlling post-release supervision period is 36 months. No fines are imposed. However, the court will assess a felony docket fee in this case. Further, there is a statement before this court that indicates that there was a $1,000 in loss to the victim, Beverly Zielke, in this case. Whether the state's requesting restitution or not, this victim is entitled to it. So the court will be ordering the defendant, joint and several with any co-defendant, to pay $1,000 in restitution to the victim. Court declares that all amounts that have been assessed in this case are immediately due and payable and may be collected through the court's collection agency if necessary. Regarding jail time credit, the court does award, and the sentencing journal entry should reflect 269 days of jail time credit that the defendant is entitled to for being incarcerated prior to today's sentencing date. I will advise the defendant of her obligation to register as a violent offender under the Kansas Offender Registration Act. Court does find that with the crime of kidnapping in this case, that the period of registration in this case is for lifetime, which means all times that you're not incarcerated, you're going to have an obligation to register as a violent offender, Ms. Scott. At some point in the future, you may have the right to seek expungement of one or more of these offenses. Certain statutory limitations do apply. Ms. Scott, if you have any questions about your right to someday seek expungement, you can address those questions to a lawyer and I'm sure get your questions answered. Under certain limited circumstances, a criminal defendant may have a right to appeal a conviction or convictions to an appellate court having jurisdiction. If they are unable to pay the cost of an appeal, the defendant may request the court to appoint a lawyer to represent them on appeal and that they be supplied with a transcript of trial court proceedings. Pursuant to KSA 223608C, you, Ms. Scott, the defendant, have 14 days after this judgment in court to file any notice of appeal with the clerk of the District Court of Butler County, Kansas. You do have the right to appeal this sentence. If the court has ruled adversely to you at this hearing, I will remind you that there's prohibitions against a convicted felon possessing a firearm, that there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. Ms. Norris, are you aware of any other sentencing-related matters that the court has not yet addressed?
No, Your Honor, thank you.
Mr. Watts, are you aware of anything further?
No, Your Honor, thank you.
I do want to make sure, though, I think it could be implied from the record, I want to make a specific finding that based on the court's incarceration order, the court's waiving bids assessments in this case. The defendant just doesn't have the financial resources to reimburse those amounts. This time, the court places the custody of Wendy Scott back into the jail under the custody of the Butler County Sheriff's Office until her custody can be transferred to the Department of Corrections to serve the remaining balance of the prison sentence, which the court has imposed here today. If there's nothing further, the Wendy Sincere Scott matter will currently be in recess, and this meeting may be ended for all at this time.
Okay, Mr. James. Can we talk? Can they get out of here?
Well, you can talk to somebody in 23 years or so. Hey, ladies and gentlemen, we're going from Judge Ricke directly into Judge Simpson from yesterday. And this is a case we've also been following a little bit. It's a couple of cases back to back, but it's a story to be told. Ladies and gentlemen, it starts right now.
Carla Green versus Dustin Mickles. Yes, there's Carla Green, Dustin Mickles, and Antoinette. State your names.
Carla Green, Antoinette.
Dustin. All right. All right. Where are we on this, folks? Because,
I filed the proper paperwork.
well, I don't know that you did. Okay, so here's the problem. I don't think that I have subject matter jurisdiction over the case, and let me just explain it so everybody knows what I'm talking about. In order for the court to obtain subject matter jurisdiction over the case, I have to have a proper notice to quit. When we were here, and I kind of explained it the last time that we were here. When we were here the last time, you were indicating to me that you gave them a notice to quit on the case. I didn't have it in my file. And I kept asking you, well, when did you serve it on them? Because I think they were saying they hadn't gotten a notice to quit. So I said that I had to have the one that has the proof of service on it. And I adjourned it out to give you an opportunity to correct that. Because if it had been served, it was. So you filed with the court a notice to quit. And importantly, on the notice to quit that you filed, it says that they had to move by February 28th, 2025. And that you served it on them March, as I'm looking at it here, March 10th, 2025. Is what it looks like to me. And it says it's served by first class mail. Assuming this document to be true, I don't have jurisdiction over the case. And in fact, I'll just say this, this document, if that's the March 10th date, it can't be true. Because you can't tell someone they have to move by the 28th of February and not give them notice that they have to move until March 10th. The only way that this notice, as it is signed by you, can make sense is if it were served on them on March 10th, they would have until April 11th or April 10th in which to move. So when I look at the face of the documents, this notice is invalid. With the dates that are on here, it can't be true.
I additionally went with that notice to quit, had this file, had the police officer do it the correct way, because that's what I was told to do from this court. The notice to quit. You said that I had to show proper paperwork of me serving them the correct way. So the first time I served them was
And we went through this the last time. You gave me, and when you were talking about the police officer serving, that's the service of the summons and complaint. That I don't necessarily, as I'm looking at it, have a problem with, that they would have received a summons and complaint from the court. They would have had an officer or somebody show up to serve that. That I'm not having the issue with, and that's what I was trying to explain at the last year. Because the document you handed me, that you were talking about that. What I told you was the notice to quit. I didn't have a copy of when it was served on that. Gave you the opportunity, you said you did, I gave you the opportunity to correct it. I'm not sure what date it was received, but the document that we received that was received by the court is a notice to quit to recover possession of the property. I will say two things about that. First of all, it doesn't match. The top portion of that notice to quit does not match what I have in the file, which leads me to believe that it's not the document that was served on them, if it was served. Then even aside from all of that, and so in reality, it's not a valid notice to quit. But even aside from all of that, if I were to say, give me the benefit of the doubt, I'll just look at it, I'll take the dates. You can't give somebody a 30-day notice, tell them to move by February 28th, and not tell them until March 10th.
Your Honor, I think it's a misunderstanding. I served them a notice to quit on February 28th because I'm following all the court steps. She said, first of all, you have to file a notice to quit yourself. And then if they don't move, you come to court, you file this paperwork, and then you come to court. So I served them, correct?
No, you don't get the question. What are you saying? You have to give me a proper service here. And I don't have it. I don't know what that notice to quit. You keep saying that you gave them one. I don't know what it says. Because your two notices to quit are different. The one that you gave me just recently is different than what was attached. The top portion is different than what was attached to the complaint that was filed. One is typed, the other is handwritten. It says move by the 28th, but the way it works on a 30-day, I tell you, if I were to give somebody right now a 30-day notice today, the 18th, I would say, if I serve it on somebody today,
Your Honor, I served it on January.
just don't interrupt me. April 18th, I would give them until May 18th to move.
Correct.
Your notice, on the other hand, says you have to move by February 28th, but I don't tell you that until March 10th.
That's the second.
That's
the second notice, Your Honor. The first notice, they told me to serve it. You have to have a 30-day notice to quit. I served them the 30-day notice to quit January the 28th. So they had till February the 28th to move.
And why don't I have a proof of service that it was given to them on January 28th? I don't have that. I told you to come back, and usually I wouldn't do it. Usually I would have kicked this case the last time. You kept telling me that you had it. I see a notice. I don't have the proof of service on the notice to quit. I gave you an opportunity to correct. What I got,
Your Honor,
is an impossibility.
Your Honor, what you got is what the court told me to do. They said file a 30-day.
You're not going to blame the court. The court didn't tell you to do this, because I think this is a falsified document if you want to really get down to it. Because the notice to quit that I have in the file is typed. The notice to quit that you gave me is handwritten. It can't be the same. I don't want to accuse you of providing false documents to the court, but that's certainly what it looks like. And secondly, the date, as I indicated, and I will say, you can smile at me all you want, but I'm going to tell you right now, if I think you filed a false document, you're going to get a show cause, and you're not going to like what happens. Am I clear? The document that you gave me is a factual impossibility. You cannot tell somebody to move February 28th and serve them on March 10th. It can't happen that way because you're telling them to move after the time that you told them to move. You can't do it. That's what's in this file. So giving you an opportunity to do that, I've given you an opportunity to correct it. You failed to correct it. I will state on the record, I think you've provided to the court a false document. This court lacks subject matter jurisdiction pursuant to the cases decided by Michigan Supreme Court. I don't have jurisdiction over this case. The only thing that I can do is dismiss it. This case is dismissed for lack of subject matter jurisdiction. Thank you. What'd you say? Ma'am, you better bring her back here. Bring her back here, Alan.
Your Honor,
Yeah, go back there someplace because when she comes back in here, it is gonna be a mess. Don't go out into the hall yet. Call security down. I don't know, so I say who wants to go next. What? They're coming down. I'll wait for her to come back here. Everybody doesn't have to wait for her. Jeff Lewis versus Michelle Kresnick.
good afternoon, Your Honor.
Good afternoon. State your name.
Jeffrey Lewis, LAWIS.
Julie Lewis.
All right. And what are we doing here today on this case, folks?
Well, this was adjourned from last week. We had to do the 30-day notice to quit. We had a hearing last week. It was adjourned till today. And she was to pay rent, which she didn't. And she was also going to try to get rent assistance, which I don't have any record of her trying to get rent assistance. So today we're asking for possession and payment.
Okay, hold on one moment. Amy? Did Ellen. Amy, do you know whether or not Ms. Krasnick has applied for assistance?
I don't have any.
You don't have any? Okay. Okay, so who wants to take the proofs? Whoever wants to raise their right hand to be sworn.
I'll take it, Your Honor.
All right. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
State your name again for the record.
I'm sorry, do you know the defendant?
Is she in Zoom?
Yes.
She is. Okay, my apologies. Ms. Krasnick?
Yes.
Okay, all right, you're here. And last hearing, there was $5,377.15 that was owed. Is that right? Mr. Lewis?
Yes, that's correct.
All right. And ma'am, how were you intending on trying to get that paid?
So I did apply for assistance and I did send the document to the court email, the 14A.
I see it.
Okay.
So that may entitle you to another week, but who did you apply to Hawk for assistance?
I thought I had to apply to the DHS first.
Okay, all right. Well, you don't have to. Did you call 961-1999, that phone number?
No, I did not. Because I called DHS and they told me what I needed to do to fill out. And so that's what I did.
So we got her right over. She thought she had to go to DHS, did not call Hawk. I think you were probably waiting for a response from DHS before you called Hawk. She doesn't have to do that. But for whatever we get that occasionally, that there's a misunderstanding as to that. But
okay,
ma'am, how many people are in your house?
3.
3. Okay, so that you know, if you have 3 people in your house, that's only going to get you about $620.
I understand. I'm also waiting
Okay.
I'm also getting my tax return, which is taking way longer than expected. But I had a question because when they served me the original document, they just wanted possession, but my lease doesn't end until July. So even if I paid the amount, they still said they want possession back.
I have this as a termination case,
Right.
and you're right. Let me just see here. What's the basis of your termination?
Your Honor, we have multiple lease violations, and from the very beginning, she became a tenant in May of 2024 without our knowledge. We didn't even discover it until January of this year when her male friend moved out and left her behind. She was basically a squatter. So we had two choices at that point: try to evict her in January or try to work something out. So we tried to work something out with her.
Okay, so let me ask you this. Do you want her under that theory to leave the premises, or do you want her to catch up rent?
Well, honestly, if she paid her rent and followed the lease, she probably could stay there till July. But the thing is that she's so far in the hole now, she never paid her security deposit. She's $5,300 in the hole, and then come May 1st, she'll be over $7,500 in the hole. And she hasn't paid rent since the 1st of February.
What happened?
Pardon me?
Hang on a second. Bring a person back? Okay. All right. So I just need to know whether or not whether or not she could stay, or you're seeking to terminate. Because if you're seeking to terminate, I don't know that she's going to be able to get assistance through Hawk.
Okay, I want to terminate right now. Just terminate. Yeah.
And ma'am, you're claiming that you have a lease? Ms. Krasnick?
That's correct.
Okay, if she's not supposed to be there, I have a lease that has her name on it.
Yes, that was the lease that we created for her in January once we discovered she was in the house. She'd been there since May of 2024.
Okay, but then she signed the lease.
Yes, in January of 25.
So, well, I have December 18th.
Yeah, right.
Okay.
That's correct.
So okay, so the problem here is going to be the notice. Mr. Lewis, because your notice indicates that you want possession of the premises, but the box also that's checked is the box which indicates that she's what's called a tenant at will or by sufferance, which means that she doesn't have a lease.
Yeah. Okay.
And she has a lease. And
okay. And Your Honor, which form is that on? Because we went through this with the
that's on. I'm just discussing notices to quit all over the place here. I'll show you.
See which one.
I can't see this here. On that notice to quit that was filed with the court.
Okay.
That notice to quit, it says you check the first box.
Yeah, delivering. Yeah, personally. Yeah, personally in possession. Yeah.
Right, and then you said you wanted possession. the first box indicates that she's basically a tenant at will or a month-to-month tenant, commonly known as, but she's not.
Right. So what,
And the second portion where you wrote on there, where it says wants possession of the property, that would not be available as a remedy to terminate her lease.
so which box would I have checked in the future when I go to check?
Well, I can't give you
give-
legal advice, but the way it reads at this point can I have my phone?
Sure.
The way the notice reads, the notice to her reads is that she's a month-to-month tenant and that you want possession.
Right.
That's not the case here because you signed the lease.
Sure.
She has a lease. So that's where we are. If you wanted to proceed by termination, I'd have to grant the judgment in her favor because I don't have a proper notice.
Okay. So what do we do now to get her to pay the $5,300?
Well, what I'm gonna suggest that you do, if she pays and you're gonna allow her to stay, because obviously she's got a lease, that she continue her efforts to try to get assistance and that you kind of work with her to get that done. So, but the fact that you're at the
$5,377.
Right. So the fact that you're there, if she were even to get assistance from Hawk outside of DHHS, you still, ma'am, would have to come up with about $2,400
Yes, I understand.
to get the 3,000 paid.
Sure.
Okay.
Yes.
What was your plan on trying to do that, ma'am?
So, like I said, I'm still waiting on my tax return, which is taken. I don't.
Gotcha. You did say that.
Yeah.
So what I'm gonna have to, here's what I'm gonna suggest that you do, okay? What I'm gonna suggest you do is work through that. I'm gonna have to dismiss this case because I can't, in the form that it's in, I can't terminate her tenancy. So I'd have to dismiss the case. I'm gonna suggest to you, ma'am, that you continue to work through with DHHS and Hawk to try to get that payment in. I understand waiting on tax returns, but then get that to the Lewises to get everything caught up.
Yes, I understand.
Okay.
Or we start again and then just.
Right, you'd start again, but you'd have to do it really as a non-payment case.
Right.
And the violations of the lease, right?
Whatever
She has a
those,
lease.
I don't know what those violations are, so, yeah, I mean, you'd have to list them out. She'd have to be placed on notice of that.
Sure.
But, okay, so at this point, I'm gonna have to dismiss the case.
Okay.
All right?
Okay, we'll start again. All right, thank you, Aaron.
All right, thank you.
Thank you. Happy Easter.
All right, and to you.
Sorry to interrupt. Your Honor, are we allowed to leave you?
I'm not clear what's going on out there.
Okay.
All right, so if you just sit tight, he was trying to explain something to me. I was trying to finish up that case and do we know?
We do now, sorry. Would you like me to?
Well, no, because I don't know what's going on out there. All right, you two, since you're the one that caused my troubles. No, I'm kidding. You two sit right there until we tell you to leave. All right? So that'd be simple. The rest of the people here are probably for my next block, which I'm just gonna let you know right now is gonna be a bit delayed, but I will get it called. And I'm gonna step off the bench and try to figure out exactly what's going on. Okay? Thank you, folks. Court's gonna stand in recess.
Hey, District Court for County of Washington, State of Michigan is now back in session. The Honorable
You may be seated. Okay, you two. She's out of the building and clear. You can go. All right?
Thank you.
Just give us a heads up when you're gonna grace my doorstep again, all right? You guys take care. Have a great weekend. Almost don't want to call anymore. All right, I guess I will. Just that.
Well, that's all she wrote, ladies and gentlemen. All I got for us today. It's been 2 hours. It's been 2 hours of very, very interesting videos. Keep an eye out. A couple of those are probably going to get merged together with their older counterparts, and you'll be seeing them as kind of a whole rest of the story type of situation. Ladies and gentlemen, come on by every weeknight around 8 p.m. Central Time. That's 9 p.m. Eastern Time. You'll see us all here chatting live, talking about the daily docket with Judge Fleischer. And I'll be releasing videos every day, all day long. Who knows what's going on? I'm constantly digging through the archives. This collection never stops. Ladies and gentlemen, thank you very much for coming out. I am your Lone Wolf Usul. I am your curator for these here videos on the court gallery. I am your host for the weekend case review. And we've wrapped another weekend case review up. This has been a great Saturday. Thank you all for coming out. Linus, it was great seeing you. Neighborhood Watch, Mom, Aussie, Tev, everybody. I'm not going to start naming names. You all know who you are. Zach, Eileen, blah, blah, blah. That's all the streamer stuff you're getting out of me for today. Like and subscribe. See you next time. I'm your Lone Wolf Usul, and I love you very much. Ozzy. Okay. Aussie is pronounced Ozzy. I stand corrected. Y'all have a great day. See ya. I stand corrected again. Guju. That's Miss blah blah blah. To you. Thank you. Thank you for the correction.